The wheel of justice may grind slowly, but it will surely get to its destination of undiluted justice. But while you wait for justice, have you imagined how that long-drawn case can be settled out of court? Yes, we mean rebuilding a culture of amicable settlement of disputes through alternative dispute resolution. Settle with Laughter is a program tailored to educate, inform, sensitize, and promote access to justice through alternative dispute resolution anchored on mediation, consensus building, restorative justice, negotiation, and arbitration. Join an alternative dispute resolution expert, Barrister Ben Odoh, on Settle with Laughter on Soul TV, Abakaliki. Settle Dispute Television is an initiative of Negotiation Powerhouse Company Limited.
Indeed, Nigeria is a home for all.
There is always this saying that he who laughs last laughs longer. And we do know that it's a wonderful experience to enjoy whatever at the longest time. Of a truth, there's only one thing that can cause one, or there are so many issues that can cause one to lose this wonderful experience, and that is conflict. Conflict is capable of making you not to laugh. And here on Salt Television, we'll make it a point of duty to make sure you laugh even louder and laugh longer. This is Settle with Laughter on television. My name is Chika Igwe, and my regular guest, Barrister Odoh Ben, the PA to the Deputy Governor Technical of Ebonyi State. Please, you are welcome to the program.
It's a pleasure, Chika, once more.
You're looking good again today with your very fine tie.
Thank you very much.
And I know the brain is as red as the tie again, and you will always be ready to pour it out like the way.
It's blue.
Okay. Please, you're welcome to the program.
Thank you, sir.
And for you, my cherished audience, I want to tell you that today we will be going back to what we have been, to where we stopped, because it is very important that we continue. It's a chain that doesn't deserve to break. Okay. Before now, we've been talking about conflict analysis. My wonderful resource person here has been discussing conflict analysis, and he gave us two stages. Or two phases, let me use your word, two phases. He said the first phase is to consult, the second phase is to diagnose, and that is where you talked about knowing the underlying factors, the real issue, and then trying to make sure you know the duration of the conflict, because it has so much to do with it. Okay, this is a way of bringing yourself into being a doctor now instead of being a learned man, but I don't have any problems with that. Okay, and as it stands, okay, having diagnosed, I believe it is now time for us to run the prescription. Because you already know the issue, you already know the underlying factors. I think what you're going to do for us now is to run your doctor. Please run your prescriptions. Please, in conflict analysis, please, can you tell us what we mean when we talk about prescribing?
Thank you very much. Good morning, viewers. Last week we stopped at prescription. We said there are 4 phases in diagnosing conflict effectively, and we looked at the first, it's to consult. The second is to diagnose. The third is to prescribe. Now, it is after diagnosing the conflict or the dispute that you'll be able to detect the root cause of the dispute. After detecting the root cause of the dispute, you'll be able to do what? To make prescription as to the antidote, as to the drugs that will cure that ailment. You cannot give drugs or medication to a patient that you have not properly elaborated with the ailment and the cause of the ailment. So after we have discussed the diagnosis, it's after this diagnosis that you'll be able to know whether party A having misunderstanding with party B, what is the cause of that conflict. You may be able to say, okay, party A is the husband of party B, and they've been having issue. And then this issue, you've diagnosed it and you discover that it is matrimonial issue. Therefore, because it is matrimonial issue, I cannot prescribe litigation, because if they go to court, they will be divorced. I hereby prescribe. Now, you now diagnose the issue of party C and D. You say it's a breach of contract. And because it is a breach of contract, I cannot prescribe negotiation, because if I prescribe negotiation, the process may end in the end of, let me prescribe arbitration to determine such matter. And I say, okay, this one is an issue between party D and party E, or party E and F, and it has to do with interpretation of status. And you discover that as an ADR expert, that you don't have the local standing to interpret status. It is the court that can interpret status. What will you do? You prescribe litigation, because it borders on interpretation of status that the court has sole jurisdiction over it. So it is after diagnosing the element of these parties, or the parties in dispute, or the disputant, that you'll be able to now get the root causes of that conflict and then make your prescription, prescribe them. Like I told you that Rule 15, Sub Rule 3D of Rule of Professional Conduct 2007, provides that a lawyer in his representation of his client shall not fail to generate ADR options for his client before resorting to litigation. The question then is, when is a lawyer expected to generate ADR options for his client before resorting to litigation? The answer is, a lawyer is expected to generate ADR options for his client after diagnosing their ailment. That option you are generating is the prescription we are talking about. And what are these options? The options include 1, negotiation; 2, mediation; 3, arbitration; 4, conciliation. These are the 4 major prescription, major options, major mechanisms. Now, there are other options, but we refer to these options as hybrid options. Why do we call them hybrid options? We call them hybrid options because these options cannot stand on their own, like the aforementioned. They need a combination of 1 or 2 to become 1. For example, you cannot have a child without the meeting of a man and a woman to be able to have a child. So that child is a hybrid option. So these hybrid options are early neutral evaluation, expert appraisal, mini trial, rent a judge or private judging, settlement conferencing, ombudsman, and then MEDAP. Now, all these options I have mentioned, negotiation, mediation, conciliation, arbitration, and hybrid processes, are only amenable to civil matters. It can only be used. There are ADR options that can only be prescribed in civil matters. We still have ADR options that are only amenable to criminal matters. You know, criminal matters will have criminal conflict. It can also be resolved through ADR. There are options that are exclusively for criminal matters. These options are: number 1, plea bargaining. They are ADR options. Number 2, restorative justice. Number 3, consensus building. Number 4, coalition building. Number 5, lobbying. Number 6, victim offender mediation. Then number 7, non-custodial measures like community sentencing, community servicing, probation, paroling, follow-ups. Now these are ADR options, but these options, plea bargaining, restorative justice building, consensus building, lobbying, probation, paroling, and then victim offender mediation, are only amenable to criminal matters. These are options prescription you can give if it has to do with criminal disputes. But if it's for civil disputes, it has to be exclusively the negotiation, mediation, arbitration, and conciliation, and hybrid processes. Now, Rule 55 provides that if a lawyer fails to do this before resorting to litigation, then that shall be tantamount to professional misconduct.
And let me even ask you, somebody just told me, because of what you said now, when the professional misconduct comes up, what happens? Because somebody called me after our last program, he's a friend. He said, I have been watching you people and that very vibrant young man. Please, I wanted to call to ask him, if a lawyer looks for my trouble, what am I going to do? And you just brought about professional matters, professional misconduct. In a situation like that, because actually the right thing is to lead people to a place where it will be easier, so that the harmony that existed before will continue. So if a lawyer fails to do this, and maybe does the professional misconduct, what exactly happens to him?
Now, look, if you look at Rule 47 of Rule of Professional Conduct 2007, it provides that a lawyer should do everything possible to encourage the parties to resolve on their own without suggesting litigation for them first. Now, if I'm a client and I brief you and decide to suggest litigation first, God help you, you go to court and lose, I will sue you for professional misconduct. Now, what do? We have a body in charge of that, the Legal Practitioner Disciplinary Committee. You file a matter, and then they will query the lawyer. They will call the lawyer to come and defend himself why he breached the provision of the rules of professional conduct.
Okay.
Yes.
That's a good one. And let me not take your time so much. You really dealt with this particular phase of analyzing conflict to prescribe. And I want to ask, you've done your prescription. You now know it's a criminal matter or it's a civil matter. As such, you now know it is supposed to be this or supposed to be that. How do you now dispense whatever you have prescribed? Prescription?
Yes. It depends on the nature and the circumstances surrounding the matter. Like I said, if you're able to diagnose this ailment and then you see the remote cause of this, you'll be able to know the prescription to make. Like the figurative scenario I've been painting, a doctor, a patient scenario. Now, the first is to diagnose, and then the consult diagnose, you prescribe. What do? You dispense. How do you dispense? After making this prescription, like I said, the prescription will depend on the nature of the nature and the circumstances surrounding the case.
Okay.
If it is is a misunderstanding between husband and wife, what do you prescribe? Mediation or negotiation. If it's a breach of contract, what do you prescribe? You prescribe arbitration. If it has to do with employer-employee conflict, what do? You prescribe conciliation. If it has to do with interpretation of status, you prescribe litigation. If it has to do with criminal matter, like they will have a victim, we have an accused, what do? You can prescribe victim-offender mediation. You see, it depends on, the problem we have is that with due respect, some of my colleagues are yet to believe that ADR is amenable in criminal matters, that ADR can be used in crime disposal. Then you can. You can use it. You can make prescription. I give you an example, sir.
Okay.
Under Section 174 and 211 of the 1999 Constitution, 1999 Constitution as amended in 211, Section 174 creates for the Office of the Attorney General of the Federation. Section 211 of Attorney General of the State. Now, under the Office of Attorney General of the State, under Section 211, the Attorney General of the State, through Commissioner for Justice, has under subsection 2 of Section 211 of the 1999 Constitution what is called nolli prosecute, supreme prosecutorial powers. What are these powers of the Attorney General? He has the power to institute any action in any court. He has the power to continue any action, continue any action. He has the power to withdraw any matter in any court. He has the power to discontinue any matter in any court except court-martial. Are you getting what I'm saying now?
Okay.
Which means Attorney General of Ebonyi State can walk into the High Court of Ebonyi State and tell any of the judges, I'm interested in this matter, I want to discontinue from this matter. And that will be the end of that matter. We'll call it supreme powers of that, and you won't question him. Now, subsection 3 of Section 211 says that in the discharge of these powers, that the Attorney General can discharge this power, subsection 2, that the Attorney General can discharge this power himself or through anybody, any officer in the Ministry of Justice. Which means now that as a private person, if I want to take up a criminal matter, what do? I will just apply for fiat from the Attorney General. The Attorney General of the state will give me a fiat. And with that fiat, I will represent him in court and discharge those prosecutorial supreme powers created under Section 211, subsection 1 and 2 for the Office of the Attorney General. Now, assuming that I have a criminal matter, maybe between two persons, a criminal matter, which Attorney General is supposed to prosecute. And I discover at the end, if you now sentence the accused person, what happens to the victim? The type of law we have in Nigeria, the sort of justice we have in Nigeria is retributive system of justice, which is one-way traffic. Let Justice Chukwudifo Oputa say that justice should not just be one-way traffic, not even a two-way traffic, but a three-way traffic. First, justice to the victim. Okay. 2, justice to the accused. And 3, justice to the society. That's what ADR is all about. Because the retributive system of justice we have is after punishing the offender. What happens to the victim? So ADR comes to create a paradigm shift from this retributive system of justice that we have to restorative system of justice, which is what justice ought to be and not what justice is. What we have now is what justice is, retributive system of justice. But what ADR is doing is gradually creating a paradigm shift from retributive justice to restorative justice. The concept of restorative justice is placing the accused person in the position he would have been, but for the commission of the crime. So what do I do under that circumstance? What I need to do is, assuming party A is the accused person, party